Hi, Tim Blankenship here with Divorce661.com. Today we're talking about a reason that your divorce judgment could be rejected and on the reject sheet that you received in the mail. This one is regarding the following. It says, the court wants the matter set for hearing. Submit Los Angeles County Form FAM 031, request for default setting, or file an appropriate motion or other proceeding to bring the matter properly before the court. Okay, what does that mean? So let's assume that you turned in your judgment to the court, it was reviewed, and then you got it back in the mail, and it says the court wants the matter set for a hearing. Generally, when this will happen, and there's a form specifically for this, it's the FAM -031. And see, what happens is the courts can only follow California law. So if you submit a judgment that kind of circumvents the law a bit, and an example of this would be, let's say you want to waive spousal support, but it's a long-term marriage. And, the California law says that in long-term marriages over 10 years, that the spousal support jurisdiction will be not terminated. It'll go on forever. So the court can have the jurisdiction over issue of spousal support indefinitely. So if you have a long-term marriage and you ask for the spousal support to be terminated, this would go against that policy, and the courts would want to speak to you about this because they would want to, when you submit your judgment, they don't have the benefit of asking you any questions. So if in this particular situation, or example rather that I'm giving you, this is just a way to get you into court so they can ask you questions or explain, hey, we can't do this, or hey, you're asking us to do this thing, but we need to talk to you because we need to figure out if we're going to do this or not. There's a lot of many reasons why they'll ask you to set a hearing. Spousal support termination is one. It could be regarding child support or child custody. And many times we'll see this happen on true default cases. True default means the other party didn't participate, didn't respond, isn't going to participate, did not sign the agreement, etc. So in those types of cases, it could also be about division of community property is another one we see it happening on. But generally when it's on true default cases, so all you do in this case, here's the fix. If you did get your judgment returned and it says set the matter for hearing, what you do is complete that form, the FAM 031, mark the reason that they said to mark for the hearing, and then resubmit your judgment with that form. So you don't want to just file that form. You want to file that form and then resubmit your judgment with that form, and then you'll get a notice in the mail that says to appear at a hearing. Usually it's several months down the road for that. So that's the fix. Pretty simple. Just fill out the FAM 031 with the request, and it'll set a hearing for basically a mini trial so the court can ask you some questions. And that's it on this one. Tim Blankenship, Divorce661.com. Give me a call if you have any questions, 661-281-0266. And just keep in mind, we offer both a full-service divorce process as well as a do-it-yourself at CaliforniaDivorceTutor.com. Talk to you soon.